So it's 12:30, so I think we'll get started. My name's Victoria Wakefield, Queen's Counsel. Thank you very much for joining me for this lunchtime seminar. I'm going to give an overview of the judgment in Lloyd and Google, which of course the Supreme Court handed down last Wednesday, and in which I was instructed for Richard Lloyd. And what I'm going to seek to do is draw out what I see as the headline points, which I suppose may be of wider interest. I'll hopefully be talking for around 30 minutes or so you can plan your lunch breaks accordingly. First of all, then, I'm not going to spend much time on the background. I'll just sketch it out very quickly. The central allegation of wrongdoing in the case is well known. It's the Safari workaround. So essentially, that allegation is that in 2011 and 2012, Google secretly tracked the internet activity of millions of Apple iPhone users and used that data for commercial purposes without the user's knowledge or consent. And we sought, on behalf of Richard Lloyd, to bring a representative action under CPR 19.6, with Richard as the representative for all affected persons in England and Wales, broadly speaking, everyone who had an iPhone, and that's around 4 million people. The claim was for damages under the statutory entitlement in section 13 of the DPA 1998, and we sued on alternative bases, so either on a loss of control or Gulati basis, or in the alternative on a user basis, and I'll come back to that in due course. And we sued on a lowest common denominator theory or basis. So essentially what we were doing was identifying the common amount of harm, the minimum irreducible common amount of harm suffered by all of the class, and suing for that, and not suing for any of the extra harms that individual class members may have suffered. We needed permission to serve out because of Google, and that application raised fundamental issues in relation to the claim. In particular, whether damages of this nature can be awarded under section 13 of the DPA, and secondly, whether the claim was suitable for representative action. So we lost at first instance in front of Mr. Justice Warby. We won in the Court of Appeal with a unanimous strong court, and then we lost in the Supreme Court. Lord Leggatt gave the only judgment with which Lord Reid, Lady Arden, Lord Sales and Lord Burrows agreed. So in this talk, I'm going to deal with those two issues which I've just identified separately. I'm going to start with representative actions, and then I'll turn to addressing damages for data breaches. First of all, then, the representative action. So I have 7 points which I would draw out of Lord Leggatt's judgment. First of all, then, I've entitled this Liberal and Flexible Rule. So coming through Lord Leggatt's judgment, we see repeated emphasis on the flexible nature of the rule, the practical purpose which it serves, and the need for the rule in order to facilitate what one might put as access to justice. So he situates the rule in case law going back 300 years, starting with Chancey and May in 1722. And in that case, the court allowed the representative action to proceed on the basis that it'd be impracticable to make all the represented persons parties to the claim, and there would be no coming at justice if all were to be made parties. And Lord Leggatt returns to that idea of facilitating access to justice, coming at justice throughout his judgment. And importantly, in paragraph 67, he emphasises that although the cases go back a long time, the modern need for the representative action is greater than ever because of mass production of goods and mass provision of services. So it's a rule with great modern application. So that really matters from my perspective, because it impacts on how we interpret all aspects of the rule, which have become cluttered with some rigidity over the years. So, for example, when Lord Leggatt is talking about same interest, he says that one has to construe that same interest requirement, and same interest is, of course, the language of the rule of 19.6, that 19.6, the representative action applies where more than one person has the same interest in a claim. He says, well, what does that mean, same interest? You have to construe it in accordance with the overriding objective and the rationale of representative actions. So that's a purposive and expansive interpretation. And he also says when it comes to the judge deciding whether to exercise his or her discretion to allow representative action to proceed, again, they'll do so by reference to those principles. And moreover, Lord Legate says, well, that will normally, usually, militate in favour of allowing the representative action to proceed. So that's point one, a liberal, a flexible interpretation of the rules which promotes the use of representative actions. Secondly, damages are available. So there have been various cases over the years which have indicated that there might be restrictions on the availability of damages, or even that damages aren't available at all in representative actions. And he says, no, there's no specific rule, no special rule which bars or limits or conditions suing for damages in a representative claim. However, it is, of course, the case that if damages require an individual assessment, then plainly a representative claim is not the right vehicle for claiming those damages. So then, what kinds of damages are available? So if we think of what's often called the bottom-up approach, so that's when you look at all members of the class and you see what harm they've suffered, what damages they're entitled to, and then you add them all together. He gives two examples actually that were given in argument, which he endorses. First of all, a class where all members of the class have been wrongly charged a fixed fee. So that would be a unanimity of damages entitlement. And secondly, the second example is where the same product has been supplied to all the class members suffering from the same defect, which reduced its value by the same amount. So that could be properly pursued with damages assessed on a global basis. So that's bottom up. But he also says, well, of course, you can have top-down assessment. So top-down assessment is where you can confidently assess damages which are to be paid to the class as a whole, which accurately assess that global loss, and then the class can subsequently sort out who gets what. And examples he gives of that are insurance cases, where there's an insurance syndicate where the total liability or entitlement is not affected by how the risk is divvied up within the syndicate. And secondly, copyright claims, in which all owners of the relevant copyright were in the class. And so there's no need to work out exactly which pirated recordings have been sold, or in what quantities, or belonging to whom. So long as you can work out globally the loss, you can make that payment en bloc, and then it's for the class to sort it out. 3 in my list of 7 points, the bifurcated process. So repeatedly through his judgment, Lord Legate refers to what he calls a bifurcated process. So that's where you have the issues that are common to the class decided in the representative action, and then subsequently that victory for the claimant in that first stage would give rise to individual claims for redress. It's a second stage. Now, he acknowledges that there may be very significant practical difficulties in many cases with that approach. And those difficulties are principally, I think, financial. And that's because the first stage obviously would not lead to any pecuniary relief. And then for the second stage, where there is pecuniary relief, it would essentially collapse into an opt-in book build. So there are real economic problems with the bifurcated approach, or at least there may be in most cases. Usefully, Lord Legate holds that there won't be the limitation problems which it was previously thought did attach to this sort of process. So there are various cases in which it's said, usually obiter, that time continues to run for the represented persons, such that individual damages claims that followed may well be time barred. And of course, depending how long the first stage takes, they may inevitably be time barred. And of course, in Lloyd and Google, we issued in 2017, and 4 years down, still arguing about service out. And that was a real impediment to anything being constructed in this two-stage model. But Lord Leggett holds in paragraph 81 of his judgment that limitation does not continue to run in that way, and that when the representative action is brought, time relevantly ceases to run for all represented persons. Presumably in the pleading for the representative action, one would say, and this is a claim for damages, and there'll be a second stage and so on. So it plainly forms part of the same proceedings. And then one no longer has the same limitation defence in the hands of the defendant in relation to that second stage. So that's point 3. Point 4, conflicts and divergences in the class. Now, as I've said, Lord Leggett's overarching approach to representative actions is a permissive and a flexible one. And that also applies to the issue of conflicts or divergences in the class. So he says, well, plainly you can't have a proper conflict, an acute conflict in the class. So if you have an issue and part of the class wants it to be determined one way and another part of the class wants it to be determined in the contrary way, then of course they can't form part of the same class. They don't have the same interest in that issue. But he says if there's a divergence of interests, that doesn't matter. And by divergence, he means if there are issues which relate only to some of the class and not to others in the class. And that is more permissive, I think, than the law was previously understood to be. And he says that in the modern age of commercial funders, of commercial solicitors firms, counsel teams, and with the sorts of class representatives who we're seeing coming through, the court can be confident that all issues in the claim will be vigorously and properly pursued, even if they don't apply to all members of the class, and even if they don't apply to the class rep themselves. So that's a useful indication. And he also says, of course, that if there are problems about divergences turning into conflicts, or if conflicts arise, then of course in the same claim, you can have several groups with different class reps, but all litigated together as part of the same litigation. 5th point, adequacy of class definition. Now, this is quite an interesting issue. It's something that's been discussed a lot and written about a lot. You know, what do you need in your class definition? So one of the interesting points is that Lord Leggett says that the adequacy of the class definition does not go to jurisdiction, it goes to discretion. So already that indicates it may be less important than we thought it was. And he says, although it's plainly desirable that the class is clearly defined, essentially it's not the be all or end all. We know, he says, that there's a general principle that the class should not be defined in a way that's contingent on the outcome of the litigation. That's the emerald supplies point. And essentially the concern there is that if the claim were to fail and the class were to be defined in that way, it wouldn't bind anyone because the class definition is predicated on success. But he also says that in terms of identifiability and people knowing whether they're in the class or not, he says there's an obvious and important difference between whether it's possible to list every single class member, and essentially says that's not needed, compared to whether it's necessary for any person to be able to tell whether they're in or out of the class. And the strong implication is that that is needed, unsurprisingly, because of course a person needs to know whether they're litigating and needs to know whether they're bound or not by the judgment. The 6th point, opt-in. So when we talk about 19.6 in general, we treat it as an opt-out regime, and that's one of its great advantages from the claimant perspective. Now, Lord Leggett endorses that view of the regime, and helpfully he endorses its use with a strong case management regime imposed by the case managing judge. So even though we don't have legislation and we don't have detailed procedure or anything like it, he says that of course a judge could say you need to properly notify the class, you need to have a regime under which they can opt out. So all of that stuff is really helpful from a claimant perspective on opt-out. But then he also says that a judge could decide that the representative action could only go forward on an opt-in basis. So only for those class members who've chosen to be part of it and chosen to be bound. So one can immediately see here from a defendant perspective that when looking at 19.6 claim, an argument to be run is that, in fact, rather than it going forward on an opt-out basis with all of the attendant advantages for the claimant side, instead, of course, it can go ahead, but only on an opt-in basis, in which case it's really like a GLO, one would imagine, and it loses an awful lot of its attraction. My seventh point, my final point, relates to costs and funding. So in terms of the cost liability of class members, Lord Leggett says that normally there'll be no cost liability of class members, on the premise that the claim fails. The court has power to make an order against them, but it's hard to envisage the circumstances in which it would if no consent has been given. And as far as the fund is concerned, the funder is likely to be ordered to pay the successful party's costs. So far, so unsurprising, I think. But then if one thinks of the circumstance of victory on the part of the claimant, critically in relation to the funder's recovery, Lord Leggett says that one of the questions of considerable importance which will arise at that stage is whether there would be any legal basis for paying part of the damages to the litigation funders without the consent of each individual entitled to them. Now, he says nothing else apart from that. That point wasn't relied on by Google. It was only touched on in argument, and so he says it'd be inappropriate for him to go any further. But plainly, that's an issue which needs to be resolved because funding is so critical to the regime. So those are the 7 points which I wanted to make about representative action. Broadly speaking, I suppose it's pro-claimant, it's pro-representative action, it's facilitative, and even in the absence of legislation or any detailed rules, it is a judge-made civil procedure made opt-out proceeding that's not limited by sector. So that's, in a sense, a radical and an important judgment. And of course, from the defendant perspective, we have that funding issue that's been raised, and also, as I've said, the opt-in alternative. So that's the representative action part. Turning then to damages in data claims, which is the second issue. I'm going to start by saying something about the tort of misuse of private information. Now, we didn't sue for misuse of private information, or MPI, as it's often referred to. Instead, we sued only for compensation under Section 13 of the DPA 98. Obviously, I'm not going to say anything about our decision in that regard, but Lord Leggett speculates that it might be because of a risk that MPI is traditionally seen as requiring individualised proof of a reasonable expectation of privacy. But in any event, coming back to MPI, I think what's interesting about it is that the two types of damages which we sought, loss of control and user damages, are plainly available under MPI. Now, so far as loss of control is concerned, that's entirely unsurprising because the case on which we relied, Galati, is an MPI case. That's the phone hacking case in which the newspapers argued that in the absence of material damage, all that could be compensated for was distress. And for some of those whose phones were hacked, no distress was suffered because ultimately in the event, no use was made of any of the information. So those people were unaware of the hacking. The judge, Mr. Justice Mann, rejected the newspaper's argument, and he said that there's no reason in principle why the law should not also make an award to reflect infringement of the right itself. And he referred to the various cases about children in which photos have been taken of children. They're obviously far too young to experience distress or suffer material damage, and nevertheless, the court has intervened and awarded damages. And the Court of Appeal affirmed that decision. Lady Justice Arden said, the essential principle is that by misusing their private information, MGN deprived the claimants of their right to control the use of private information. Now, interestingly, Lord Leggett endorses that approach. And he says that the common law now recognises as a fundamental aspect of personal autonomy a person's freedom to choose and right to control whether and when others have access to his or her private affairs. Turning to user damages under MPI, well, first of all, what do I mean by user damages? I mean what we used to call root and park damages, the kind of damages that were recently considered by the Supreme Court in One Step and Morris Garner. So they essentially compensate when wrongful use has been made of another's property, and the theoretical mechanism by which quantum is arrived at is that you have a fictional negotiation between the parties with the wrongdoer fictionally paying the price that they would have paid to be allowed to do the thing that they wanted to do. And again, the language is of control. So Lord Reed in Morris Garner says, the rationale of such awards is that the person who makes wrongful use of property, where its use is commercially valuable, prevents the owner from exercising a valuable right to control its use, and should therefore compensate him for the loss of the value of the exercise of that right. He takes something for nothing, for which the owner was entitled to require payment. So Lord Leggett, in our case, says in terms that user damages should be available for MPI. He says a claim in tort for MPI based on the factual allegations made in this case would naturally lend itself to an award of user damages. So there are 2 points I'd make here. First of all, what's interesting is that Lord Leggett clears up the doubts which may have attached to the availability of user damages in an information or data context. And he says that, of course, the data, the BGI browser-generated information, of course, that had commercial value. So it can't be doubted that it's a commercially valuable asset. And he says there's no inconsistency between it being private and still being treated for these purposes as a commercial asset. And he says when the defendant's very purpose in wrongfully obtaining and using private information is to exploit its commercial value, the law should not be prissy about awarding compensation based on the commercial value of the exercise of the right. So that takes the law further on. And then interestingly, and helpfully from my point of view, he says that the hypothetical negotiation should not take place on a standard ex ante basis. So essentially we'd argued that because Google contracts, obviously before the event, but with everyone who uses Google on standard terms, we said that essentially the user damages assessment would similarly have to be a standard term across the class shift in how Google did business. And that meant that it didn't actually matter whether Google made full use of its permissions or not subsequently. And Lord Leggett says, well, that's not right. The way that user damages works is that you have to see what wrongful use was made. And then once that's been established, after the event, as it were, you work out what the fictional price would have been to do that thing. Now, I don't think he goes quite as far as to say that that would always have to be individualized, and I'm going to come to lowest common denominator shortly, but certainly what he does say is that it has to be calculated, the price, the damages has to be calculated by reference to the actual wrongdoing rather than a change in permissions at the beginning. Turning then to section 13 of the DPA, and I'm now really in the part of the judgment that went less well for us. So we saw loss of control, Galati damages, and the alternative user damages. And Lord Leggett held that neither of those is available under section 13. And so they're not available in an individual claim. Richard Lloyd, suing on his own account, could not sue for either of those types of damages under section 13. So Lord Leggett placed particular weight on the language of section 13 and of article 23 of the directive which it implements. And those words are, an individual who suffers damage by reason of any contravention by a data controller of any of the requirements of the Act is entitled to compensation from the data controller for that damage. And so he says that that linguistic structure naturally means that contravention and damage are 2 separate events. You can have contraventions that don't cause damage, and what you have to do is show contravention, causation, and damage. And what we're doing in our claim, what we sought to do, was wrongly elide all of that and rely on the contravention as the damage itself. He also says that none of the requirements of the DPA is predicated on control over personal data by the data subject. He said, well, the data controller has the control, The nearest analogue to control is consent, but that's neither necessary nor sufficient to render processing compliant with the Act. And he then turns to our common source argument. So that was the principal mechanism by which we said Ghilarti loss of control should apply to data claims. In particular, we relied on the various authorities and sources which say that data protection is a species of Article 8 right, and that its paramount objective is to protect privacy and private information. I mean, not least Article 1 of the directive says that, so there were some pretty good arguments in support. But Lord Leggett rejects that read across. In particular, he says the approach of the domestic tort, the MPI tort, is not mandated by Article 8. So although it's the domestic way, the England and Wales way of meeting those Article 8 objectives, it's not required by Article 8. And instead, it really is just a domestic tort with that objective in mind. And similarly, he says the EU had a wide margin of choice when deciding how to protect data rights and how extensive the compensatory entitlement should be. And again, there was no external human rights basis for saying that there has to be compensation for every breach. And he also says there are material differences, in fact, between MPI and the data regime, which makes that sort of read across even less appropriate. In particular, he says data protection applies to all data, not just private data, and the fault standard is different. So data protection is a reasonable care regime, that's a defence to Section 13. In contrast, MPI is a deliberate act regime, strict liability for deliberate acts. So he's against us on Ghilarti loss of control, and for essentially the same reasons he's against us on user damages. So he says that the compensatory entitlement under Section 13 arises only in relation to material damage or distress. The user damages are unavailable. So that's where we end up on Section 13. Now, of course, as has been remarked already, one aspect of Lord Leggett's judgment is that he expressly says he's not addressing the GDPR. Now, the GDPR had featured in argument below, the Court of Appeal in at first instance. And he says, well, he's not going to address it because it's wrong as a matter of principle to have regard to subsequent legislation when construing prior legislation. So he just doesn't address it. But of course, the door may be to an extent open for the GDPR position to be considered going forward. Finally, I'd like to say something just about lowest common denominator. So plainly, in Lloyd and Google, there were massive variations in the class if they'd all sued individually. And one can immediately think of the variations in their differing positions. So they'll have had very different volumes of data affected. One person might browse multiple sites for hours each day, another once a week, once a month, who knows. They might go onto sites of differing degrees of sensitivity, some very embarrassing and personal sites, some just doing your shopping or booking a villa for the summer holiday or whatever it is. And also, they may have been very differently affected by targeted advertising. Some might have found it very useful. They may have been entirely benign. Others may have had a loved one or a friend or a colleague see a targeted advert come up and had a very embarrassing bit of their private life revealed because of the targeted nature of the advertising. So a very big difference in all those positions of the different class members. Now, of course, the representative procedure doesn't accommodate an individualised inquiry into the circumstances of the different class members. Lord Leggett says that in terms, and we knew that was the position. So what we did was to sue for lowest common denominator. And as I said at the beginning of this talk, we sought to identify the part of everyone's claim that was the same and to sue only for that. And we disavowed any reliance on any individual facts that would push individual entitlements any higher. Now, the High Court didn't like that at all. He said it was artificial. The Court of Appeal obviously was happy with it. And Lord Leggett isn't too negative about it. I might even, on a good day, say he's positive-ish about it. And so he notes that Google says that a class representative does not have the authority to waive or abandon part of a class member's claim. But he also notes our response, which he calls pragmatic, that limitation has now expired at Lloyd and Google, and in any event, it's better to be able to sue for something than for nothing, which is, after all, the realistic alternative. And he says he doesn't think it's necessary to enter into the merits of this issue, but I am prepared to assume, without deciding, that as a matter of discretion, the court could, if satisfied that the persons represented would not be prejudiced and with suitable arrangements in place enabling them to opt out of the proceedings if they choose, allow a representative claim to be pursued for only a part of the compensation that could potentially be claimed by any given individual. So as I say, that's relatively positive. Now, of course, in the data context, we come up against the issue of the threshold of triviality, and that the damage suffered has to be more than de minimis or more than trivial. And Lord Leggett held that in our case, the lowest common denominator was lower than triviality or lower than de minimis, and so we wouldn't get through on that basis. The way he puts this point is to say that if no individual circumstances are taken into account, the facts alleged are insufficient to establish that any class member would be entitled to damages. This is, I should say, on the alternative basis that loss of control damages might be available in any event. But although he expresses it by reference to individual circumstances, I think when you read that as part of his lowest common denominator assessment, his conclusions or his concerns about triviality would equally be met by drawing a tighter class, a more circumscribed class, with a higher degree of lowest common denominator, so a class that was just more affected. And so that still could be brought on a uniform basis if damages were available, on a uniform basis without needing to descend into individual facts. So to draw this second part of the seminar together, we're left with section 13 being available only for distress and material damage. And it may well be the case that in the vast majority of cases, those heads of loss can only be made out by reference to an individual assessment. That might not always be the case, but in many cases it will be. Lowest common denominator, as I've said, I think lives to fight another day. And of course we have MPI, and on the basis that it may be possible to meet the constituent elements of that tort across a class with the reasonable expectation of privacy, and this is all going to be quite fact-specific stuff, then of course we do have user damages available, and we do have loss of control damages available. So that brings me to the end of everything that I wanted to say today. I hope that's been of some use. You can all now have your sandwiches, and I hope to speak to some of you at least soon. Thank you very much. Bye.